Thank you for visiting the Combs Waterkotte website and our YouTube channel. Our criminal defense law firm in Illinois has over 500 perfect reviews and a long history of client satisfaction, dismissals, charge reductions, and victories. We have created these audio articles to help protect your freedom, reputation, and rights. If hired for your case, we will not give up until you get fair justice. Class 1 Felony Defense Lawyer in Illinois. As the second highest class of criminal offenses in Illinois, Class 1 felonies cover a wide range of crimes, from murder to drug possession. No matter what felony charges you may be facing, the leading Southern Illinois criminal defense attorneys at Combs Waterkotte will fight for your freedom. Our nationally recognized firm has an unmatched record of success, and we can leverage that experience on your behalf to protect your rights at every turn. Illinois Class 1 Felonies and Felony Classifications. Explained. The common law traditionally divided criminal offenses into felonies and misdemeanors. Informally, the most serious penalties were reserved for felonies, while misdemeanors were subject to less severe punishments. This law recognized that not all felonies were the same, though. Homicide was seen as less serious than larceny, for example. Among homicides, murder was subjected to more severe punishment than manslaughter. States like Illinois maintained these distinctions when they codified their criminal laws. The state divides felonies into the following 5 levels, in descending order of severity: Class X felonies, Class 1 felonies, Class 2 felonies, Class 3 felonies, Class 4 felonies. Class X felonies are the most serious of the classified felonies. Above these 5 classifications, Illinois has 2 additional classes for habitual criminals and murderers. Generally, only habitual criminals and murderers face life imprisonment, while offenders convicted of lower-class felonies receive sentences with a definite term. Illinois statutes covering Class 1 felonies. The Illinois statutes classify many offenses as Class 1 felonies. This classification is most often applied to sex crimes, violent crimes, and drug crimes. Some property crimes can also be charged under this classification, but the property must be particularly valuable. The following examples illustrate some of the offenses that fall into this classification. Sex crimes. Many sex crimes are considered to be Class 1 felonies, including producing child pornography, possession of child pornography with a prior sex crime conviction, criminal sexual assault, aggravated criminal sexual abuse by a supervisor over 17 against a victim under 18. Indecent solicitation of a child if the solicited act would have constituted aggravated criminal sexual assault or predatory criminal sexual assault of a child. The punishment level for some of these offenses can be increased to a Class X felony based on the circumstances of the crime. Violent crimes. Second-degree murder is a Class 1 felony. However, it is sentenced differently from other offenses in this category. Second-degree murder occurs when someone commits a homicide that would qualify as first-degree murder, but they were either provoked by sudden and intense passion or mistakenly and unreasonably believed the killing was justified. The following violent crimes also qualify as Class 1 felonies: voluntary manslaughter of an unborn child, aggravated battery against a police officer, aggravated battery by torturing, strangling, or delivering a controlled substance, third or subsequent offense of luring a minor, human trafficking for involuntary servitude by restraining or threatening to restrain, human trafficking of someone 17 or 18 for sexual servitude, aggravated intimidation to further gang activity, criminal street gang recruitment on school grounds. Conspiracy to commit violent crimes can also qualify as a Class 1 felony. Specifically, conspirators planning a Class X felony, including first-degree murder, can be charged with a Class 1 felony. Drug crimes. Illinois has taken a hard line against drugs by imposing Class 1 felony punishment for any of these drug offenses: possessing at least 1 gram of heroin, fentanyl, or cocaine, possessing at least 5 grams of LSD or MDMA, possessing at least 10 grams of morphine or ketamine, possessing at least 50 grams of peyote, barbiturates, oxycodone, hydrocodone, or amphetamines, manufacturing less than 15 grams of methamphetamine, delivering at least 15 grams of methamphetamine, possessing with intent to deliver at least 5 grams of methamphetamine, possessing at least 15 grams of methamphetamine. You can also face charges for possession of marijuana under certain circumstances despite decriminalization. If you do not have a state-issued license, you can face Class 1 felony charges for possessing over 5 kilograms of marijuana. Property crimes. A few property crimes are classified as Class 1 felonies, including theft of property over $10,000 from a school, church, or government, theft of property over $100,000, theft by deception by falsely posing as a landlord to obtain rent or a security deposit of over $10,000. It's important to note that if the accused allegedly steals property over $500,000, they are typically not eligible for probation in place of imprisonment. Possible defenses for Class 1 felonies in Southern Illinois. We can employ a number of criminal defense strategies on your behalf, depending on your charges. While our exact strategy will be customized to your specific circumstances, some common defenses we may leverage include lack of knowledge, alibi, and Fifth Amendment violations. Lack of knowledge or intent. Prosecutors must prove every element of an offense to secure a conviction. These elements almost always include your knowledge of the circumstances and your intent to bring about the prohibited outcome. For example, to commit theft, you must intend to deprive another person or business of the property. If you mistakenly believed it was your property, you lacked the intent to steal it. Alibi. An alibi involves using witnesses and evidence to show that you could not have committed the crime. For example, your alibi might be established with a witness who saw you somewhere other than the crime scene. It might also include forensic evidence, such as a DNA mismatch. Fifth Amendment violation. The offenses charged as Class 1 felonies tend to involve high-profile, serious crimes. As a result, the officers and detectives investigating the case might employ aggressive or even coercive tactics to force you to confess. Fortunately, the Constitution's Fifth Amendment protects you from some forms of self-incrimination. If the police questioned you after you asked for a lawyer, threatened you, or assaulted you, anything you said might not be admissible in your case. Why you should choose Combs Waterkotte for Southern Illinois, Class 1 felony defense. When you're facing a Class 1 felony in Southern Illinois, you need a defense team that knows how to navigate high-stakes cases and protect your rights at every stage. Our attorneys bring decades of insight, strategy, and courtroom skill to your corner. Experience. Over 60 years of combined defense experience. Extensive background in serious felony cases. Proven success with homicide, violent crime, and felony theft matters. Skilled in investigations, negotiations, and trial advocacy. What you get. Compassionate, confidential legal support. Aggressive defense against investigators and prosecutors. Guidance from arrest through every stage of court. A committed team fighting for fairness and the best possible outcome. How we defend you in a Class 1 felonies case in Southern Illinois. Class 1 felonies arise from serious accusations. However, this does not mean you should give up. Depending on the circumstances, we may be able to poke enough holes in the prosecution's case that the state drops your charges or reduces them to a misdemeanor or lower-level felony. Our firm can also present mitigating evidence that persuades prosecutors to offer a fair plea bargain. We start building your defense by listening to you. Our attorneys use your side of the story to identify evidence and witnesses that support your case. If the prosecution does not work with us to reach a fair outcome, we can advocate for an acquittal at trial. Contact Combs Waterkotte to build your Class 1 felony defense today. Many Class 1 felonies in Southern Illinois are ineligible for probation and, as a result, can mean at least some prison time. It is vital to place your future in the hands of seasoned attorneys who care. At Combs Waterkotte, we have the experience and legal skills to fight for your freedom and future. Contact us online or at 618-88-CRIME to learn how we can help you today.